Thank you, Judy. Let's open it up for questions, Barbara.
If you'd like to introduce yourself and what state you're from, and go ahead and ask your question, and you can direct it toward the presenter of your choice.
This is Dave Donnelly in Anchorage. It seems like other than Richard's argument against having a constitutional convention is that doesn't trust government to do it, should do it through grassroots. The counter-constitutional convention people have any opposition to the states pursuing single-issue amendment proposals? It seems like there's no downside to that. The argument that the results are zero but the risks are too high doesn't apply to single amendment Article 5 proposal by state legislatures, especially things like the countermand amendment or the repeal amendment proposals would seem to restore federalism. And the statement that there's nothing wrong with the Constitution overlooks the 17th Amendment's alteration of federalism and all the federal court decisions that have altered the balance of federalism over time. Why not do these single amendment proposals through state legislatures to try to balance those things that have changed the Constitution?
The first thing on that is the unlikelihood of being able to have a single issue. Even if you look at the Convention of States model resolution, one of the things that it's calling for is the amendment of the federal government's jurisdiction and power. Well, the only thing the Constitution addresses is the power and jurisdiction of the federal government. So that...
Richard, you're not talking to my question. My question was very specific. What are your arguments against the specific amendment proposals, not the Constitutional Convention proposal, the specific ones where things like a specific proposal like the repeal amendment or the countermand amendment?
I am addressing your question. There is no way to limit, in my opinion, there is no way to limit an amendments convention. There just isn't. If you read the article, most of these questions can be resolved by simply looking at Article 5. It's clear. It's very clear. You don't even have to ask for a specific topic. All you have to do is say that you want a convention. That's all they have to do. They can't limit it to a specific convention. And so that's another fantasy. Again, they are doing what they accuse the federal government and the Supreme Court of doing. They're trying to interpret it in a way that they wish it was, not in the way that it is. So I don't think that you can have a limited convention, and even them suggesting that they tell you that we're going to have a limited convention. The reality is they want a limited, unlimited convention. And so I don't think that you can do that. That's the problem.
You know, that you shouldn't use the argument to tell what other people's motives are. I mean, you're arguing motives, you're not arguing the issue. I have no interest in having a sweeping constitutional convention, but I do specifically support targeted things on targeted issues like right to life and restoring federalism. When you argue my motives, that's not right.
I'm not arguing motives. I'm arguing the English language. It says, and there have been several, including South Carolina, that have filed requests that parrot that language. I'm telling you that when you ask for a convention, if you think it's controlled by the request, if you ask for a convention to amend the power and jurisdiction of the federal government, that includes everything, because that's all the Constitution is about.
And once again, you're arguing something that I didn't ask about. I asked specifically about the countermand amendment and the repeal amendment proposals. And you're going off and arguing a totally different proposal.
No, you jump to the motive issue. What I'm telling you is you cannot have a single issue convention. That is not keeping with the Constitution and the very purpose of bringing this deliberative body together. You cannot do that. You cannot limit it in that way.
Okay, can I interrupt and ask if there are other questions?
Yeah, I have a question. This is Bill Spearman in Anchorage. That's not to any particular individual, but maybe to the group as a whole, and maybe they can respond as their hearts lead them. There's been talk about enforcing the Constitution. What I'm wondering, what's the role of state nullification of federal laws that are deemed unconstitutional by the state? Does nullification have a role?
What I would say is this. Number one, there is no such thing as unconstitutional law. The Constitution's very clear about that if you go to Article 6. Any law that is not, or any enactment that is not in pursuance of the Constitution is automatically nullified under Article 6. And we've got 200 years of Supreme Court cases that tell us that they never become laws as if it was never enacted. It's not enforceable. It gives no rights. And so it's not state nullification that's the solution. It's constitutional nullification. But the problem with constitutional nullification is you still have to get the states to get off their butt and protect the rights of their citizens, and that's not what they're doing. Since 1903, anyway, the states have been taking money from the federal government and selling out the rights and liberties of their citizens. In 1903, they passed the Dick Law, and what that did is it gave money to the states to convert their militia, the militias of the states, into a federal standing army. And that was the beginning of the end. And what they did is they converted the militia into a standing army so that they could send the army overseas. That's what Teddy Roosevelt wanted to do. And frankly, some of the same people behind that effort, behind the Dick Law, are the same people that are behind this, that originally started this movement back in the 60s. It's the same folks that are involved in it. And because they have their own personal agenda. But there is no such thing as state nullification, but the states do have a duty to not allow the central government to come in and try to enforce a federal enactment that is unconstitutional. They have that duty under the sovereign principle of allegiance and protection, and their duty is to interpose. They have to literally get between the federal government and the citizens and say, you are not going to come in here and violate our rights. And the states do not do that. And we've got to get the states under control before we can correct our current situation.
Mike Coons and Palmer.
Oh, great. Go ahead, Mike.
Okay, in answer to Judy's question, I'm kind of throwing it back at you a little bit on this. Yeah, we as citizens go to the polls, and we as citizens look at our legislatures or people that want to be our legislators. I don't know what state you're in, but I can speak for Alaska. And in Alaska, I got citizen legislators. I don't have politicians. I got Mike Dunleavy, one hell of a citizen legislator. I got Shelley Hughes. I got Lynn Gaddis. I got Mark Newman. I've got Charlie Huggins. The list goes on and on. These people are there working for us. They are our citizen legislators. There's not any of those people that I just named, there's not a one of them that wouldn't cringe if I called them a politician. We gain control by the people telling our legislature to enact an amendment. We follow those debates. We shape the direction. We do it all the time. We're doing it right now in this session. In the other 34 states that make application, then the convention, and then the amendment goes on up for 38 states saying yes or no. As to Hawaii, on that question on Hawaii on the Second Amendment, that is one state. Maybe New York might, maybe Illinois might, if they even know about Article 5. But 40 states right now have CCW laws and some of the strongest pro-gun, pro-Second Amendment laws that this nation's had in a long time. So I don't believe in this thing that our states have turned against us. So no way would an amendment ever get 34 to even get to a convention, much less 38.
This is Charles. I'll try to address a couple of thoughts that were presented by Judy and others.
Yeah, can I address, since he kind of gave me that question, or?
Okay, go ahead.
Sorry, I won't be long, Charles, because I'd love to hear what you have to say. But you mentioned the Hawaii thing, and that was just one state that was mentioned. But I'm not sure if you're familiar with all of the amendments that groups like Move to Amend are proposing. But people can visit Defend Not Amend, and there's a section on there called Is This a Push by Conservatives? And you can look at the list of everybody who's signed up on Move to Amend to make amendments to the Constitution. You can also look up to see who. You can also look up and find information on your own as far as how Mark Meckler, who is the National Director of Convention of States, has been working side by side with MoveOn.org. There's a picture of him. If you just Google it, you can find information about how he's been working with the Aspen Institute, which is in Colorado, which is my home state. So Mark Meckler's been working with groups, leftist groups, far leftist groups. Not that this is left versus right, because I don't believe in that. But he's been working with the Aspen Institute in Colorado and MoveOn.org in many of these ways to what he calls an open government. So that's the National Director of Convention of States.
Let me throw this out there for you for information for you too. So you have another avenue of watching what the states are doing. There is a website out there. It's called the Article 5 Library. It lists all Article 5 calls or all Article 5 applications to the Congress. And I just looked at that this week, and there was nothing in there up until New Hampshire on the balanced budget, and that's the latest one in 2012. And I'll leave it at that.
There's another website called Friends of Article 5 Convention, FOABC, that has them all listed and categorized and as far as the applications. So, yeah, we're very aware of that. Thank you.
All right. If I can, I'd just like to inject a couple of thoughts here. First of all, the problem that was presented, I think it was by Richard, dealing with you can't, under Article 5, you can't have a safe or successful convention simply because it's not in Article 5. The point that I'd like to make on that is simply this, that Article 5 is a new beginning. I said this before. It was there for the purpose of it was there for the purpose of affirming and securing state sovereignty that would be defined by the state legislatures at a later time. That is where we're at today. The fact that the state legislatures have this authority does not depend on legal precedent. It doesn't depend on what the founders did. They actually pass this on to them, and they decide what the convention call is. They decide the parameters of the delegates at the convention. And when we consider this, the idea that a delegate somehow rules the people who sent them flies against any kind of reasoning. The fact is that in the Baptist community, as an example, when they have conventions, they have delegates who come from the different churches, whether it's their annual convention or state conventions. And when they go to that convention, they don't go telling the convention what the agenda is. They don't go deliberating on anything like that. They just decide that the agenda that's presented will be passed or not passed. And they decide at that point whether whether they will make recommendations for next year's convention, and then the leaders of that denomination decide if they will accept those recommendations. Now, the same is true for the legislatures. They are the boss. They're in charge. They're the ones who decide who the delegates are and what their duties are. They send the delegates to the convention as ambassadors, not as free agents. And they say, okay, listen, you've got to do such and such. You do have a problem. You've got to vote in such a way that will help to get this particular pre-approved amendment passed. But at the same time, you need to coordinate with the other state the other state delegations to get the intended purpose that you have in this delegate resolution. And then when you look at Article 5 and you say, why is it that the claim is made here on that by Richard and by Jeff, that you can't have a single-issue amendment. That's nonsense. The fact is that delegate resolutions are a contract between the legislature and the delegates, no one else. Article 5 doesn't prohibit that. Article 5, and anything in our history doesn't prohibit it, because they're operating at a new beginning. They're saying, this is what we want now because we're about to fall apart as a nation. Personally, we've got to do this. Why? Because there's another 50 million babies at risk. Our Constitution didn't protect them. They've got to be protected now. And I'm not willing to even sacrifice a little bit of time to let these kinds of arguments contrary to Article 5 go forward when, in fact, we have a vehicle. We can have a safe convention. And yes, there are risks, but the risks can be controlled. And we've got to proceed on that basis.
I would like to ask you to show us where in Article 5 it says all those things that you just mentioned.
It's in the idea that the state legislatures are sovereign. The point is, when you're sovereign, you don't ask permission from somebody to do something. You just
Article
do it.
Article 5 is very clear. Article 5 is very short and it's very clear. It doesn't have all that stuff in there that you just said.
No. What you're trying to do is establish legal precedent. What you're trying to do is say that legal precedent rules, historical history rules. That's not what happens with Article 5. Article 5 is a new beginning. It requires 3/4 of the states to ratify anything that would come out of a convention, but the definitions of the convention are in the hands of the legislatures. It's a whole new beginning. It's not the same as the Constitution Convention. It's an entirely different purpose. The purpose of Article 5 is to preserve the Constitution through proposing amendments. And the rules for how to do that are in the state legislature's hands. Again, I repeat, if I hire you to do something and I say, I want you to do such and such and such and such, and you go out and you say, I'm not going to do it unless you do such and such, and whether you have my permission, the point is that I'm supposed to ask your permission to go ahead and do what I told you to do. I would fire you on the spot. You're my emissary to do what I tell you to do because I'm paying you. And the delegates are the same. They're not the delegates of the founders. They are literally ambassadors of the legislatures, and as ambassadors, they are answerable to the legislatures. That's what our delegate resolution is about. Now, why is it a delegate resolution? Because there's a contract between the legislatures and the delegates that the legislature chooses to send to the convention. The governor has no say in this. Other agencies in the state government have no say in this. Actually, all of the decisions that are made by state legislatures, including the one in Hawaii, when it comes to Article 5, are moot. They don't have any control over the direction of the nation. Look at the pro-life community. They've been struggling with incremental legislation for 41 years. Now, I take it took them 15 years to get started, but for the last 25 years. And they have gotten almost nowhere. There are some babies that have been born alive, and the crisis pregnancy centers have certainly made tremendous inroads, but the fact remains that the legislatures in the states had no authority to overturn Roe versus Wade. We had to amend the Constitution to overturn Roe versus Wade or get the Supreme Court to make a different decision. That means that in the future they could make the decision back again.
Your comment that whether the states through the Article 5 convention method, whether they're proposing a limited convention on a single subject or on a single amendment, the delegates, the commissioners, as they're more properly called, are, as you say, bound to their state legislatures. They are not free agents.
And I appreciate that insight. And this is one of the reasons why I am in favor of what you guys are trying to do. The only thing is I think that what you're doing is you're opening up a risk factor that I would like to keep from happening. But the fact is, if you send those delegates with instructions for how to address a subject, that doesn't mean they come out of that convention with anything that's good that can be ratified by the 3/4 of the states. You've got 3 or 4 different main subjects, and then under each one, these delegates are going to have to figure out what the sub-subjects are. I mean, just thinking about reigning in government, my goodness, there's 100 different ways you can reign in government. But the delegates are going to be told how to do that. I mean, they're going to be told to decide that.
Delegates will attend the convention with instructions and model legislation from their state legislatures.
That's true, but it's not in a definitive form. It's not to where you can actually assure yourself that you're going to have a safe convention. With things like a single-issue countermand amendment,
body, as the Article 5 convention talks about.
I didn't hear you, ma'am.
But it will be a deliberative body, which is, we think, in concert with what Article 5 convention.
Article 5 does not call the delegates as a deliberative body.
No.
By implication, the state legislatures alone are the deliberative body. No one else.
Right. Through their commissioners.
But not through their commissioners. They determine how that is going to be exercised. They have the final authority, the legislatures. They say to these delegates, look, this is how we want you to conduct yourself. That means the delegates are ambassadors and not free agents. That's a very important fact. But I will just qualify this in regards to what you said about the subjects. My concern with COS is that they're on the right track. And they're trying hard, you guys are trying hard to accomplish something that has never been done before. And again, I've had good, long deliberations with your leaders. But the fact is, they have missed the point that the state legislatures right now have a historic opportunity to retain state sovereignty if they don't abdicate it. If they abdicate it, they won't get it back. And from this point forward, after that convention, it'll always be the delegates that they will rely on. It'll never be themselves. That's what I'm trying to defend. I want the state legislatures to retain the authority and the sovereignty they have right now in Article 5, not to surrender it based on flawed constitutional history or legal precedent. Legal precedent has no bearing on this. What is important is the legislatures decide what it is. That's what I want to see happen.
Although the Supreme Court in adjudicating Article 5 cases have said that historical precedent has merit.
There is no precedent with Article 5 because there's never been an Article 5 convention. And you can amend it all day long. Senator David Long has gotten Indiana to adopt some very embarrassing legislation that's going to make it a felony if the delegate doesn't do what they take an oath or a sacred promise to do as a delegate at a convention. How hypocritical is that when the Indiana legislature won't uphold the Constitution as it is? It's like, do as I say, not as I do. And you're going to send these folks to a convention. I don't care if it's a single issue or if it's an unlimited convention. It's going to be orchestrated by people that won't uphold it now.
If it's a single issue and it's controlled by a delegate resolution, it doesn't mean that you have to put them in prison, but it means they have to be bound or they're going to be recalled. That's what it means. And they have instructions on how to organize that convention. They have instructions on how to find officers, how to join with other delegates, delegations that they can join with. But let me go back to the lady's question just a moment ago, dealing with a statement about the Supreme Court. I would like to add this thought. If we can get it through our heads that sovereignty in state legislatures trumps everything, including whatever the Supreme Court said.
The people are the ultimate sovereigns. The state sovereignty is no different than federal sovereignty.
If Article 5...
It's all one from the people.
Let me give you the condition, and then I'll tell you my conclusion. If Article 5 allows state legislatures to be sovereign with authority that limits them to proposing amendments, they can then make any kind of a proposal that they want, and they don't need the Supreme Court's permission. They don't need to ask the Supreme Court or Congress or anyone else because they're sovereign. That's the difference between what you guys are saying and what I'm saying.
Absolutely not, Charles. It's the same thing because they don't need the Supreme Court's permission and they don't need Congress's permission and they don't need the President's permission to uphold the Constitution as it's written right now. And they don't do it. And they have that authority now and they don't do it. Changing the Constitution is not going to get them to exercise any more authority than they already have.
Remember what I said before about the provision for enforcement through the states? That's how it's done. What the purpose of a law is to control conduct. And when you put an enforcement clause in the countermand amendment and you say, look, if the federal government won't violate an intentional prosecutor, the states can, that's going to put the fear of God in these people. They'll do it, just like they did with Roe versus Wade or with Obamacare or just like they did with Common Core or Keystone Pipeline. I mean, they won't dare do those things if they know 30 states can knock them out.
The founders said that this Constitution would only work for immoral and religious people, that it was totally unsuitable for any other kind. But we're no longer a moral and religious people. Until we fix ourselves, we can play this charade, getting the government and replacing the fox with the wolf, watching the hen house with state legislatures.
Your arguments are upside down.
Could I interject for a second? I'd like to know if there are any other questions before we continue.
I have a few questions, and I guess they're addressed to defend, not amend, and they're very sincere questions. You've given me a lot to think about. When I first heard about Article 5 conventions, I was hopeful that this might be a way out. And I still view these Article 5 conventions as a good idea, but it's a very complex issue. My question is that if nullification is a valid application, and if constitutional nullification is valid, and if Article 5 is valid, and we understand that the states are sovereign, and we understand that the sovereignty is in the people, and we know that the federal government is out of control, why aren't there several levels of practical ways of going about trying to take back control? It seems to me that the progressives have used every possible tool they have in the toolbox to erode our Constitution and our rule of law. Why is it that we have to have one or another tool that we use in the toolbox? It seems to me that there should be several different ways that we can go about taking back control.
Well, the answer to that is there are several different ways, but Article 5 is not one of the ways to rein in the federal government. That was never the point of Article 5. If you go look at Federalist 28 and 45, that's what the whole Federalist principle was. The states and the people keep the central government under control. That was the mechanism. It's like Mao Zedong said, all political power comes out of the barrel of a gun. It doesn't come from a piece of paper. But George Bush reputedly said, the Constitution's just a GD piece of paper. There's a lot of people up there that think that. We have a lot of Supreme Court judges that think that. Jefferson said the problem with the Supreme Court was they didn't impeach enough of them, and I think that's true. But until the people, because ultimately we are the sovereign, we're the king of this country, until we get our moral and patriotic self in line and do our duty and hold these people accountable, nothing's going to happen.
Okay.
And something else I'll say is that if you think this is a progressive versus a conservative issue, you don't know what's going on. Let me tell you, there are neocon conservatives that are controlling the Republican Party that are trying to get us in the same position as the progressives are. And they're playing this little back and forth game with us.
Can I follow up with you? And I'm just going to ignore the progressive versus conservative. That wasn't my meaning, but I'm going to ignore that for now. I just want to follow up with you, and you make statements like, the people of the country, we need to get ourselves in order. Give me the practical applications of what that looks like. Because I think everybody that we're talking to here has the same objective, it has the same outcome, but I don't understand what you're talking about when you talk about getting ourselves in line and the people standing up. Those are all really ambiguous ideas.
I don't think they are very ambiguous ideas. We just had this happen in Colorado where they had some people running for office that told the citizens that they supported the Second Amendment. As soon as they got in there, they passed gun-grabbing bills, and then their excuse was, well, there's no limit, it is unrestricted. And the citizens got together and they kicked their butt out because they had the power of recall. They kicked 3 of them out, and I think one of them resigned. That's part of what I'm talking about. I just went to a Republican meeting and heard a federal senator tell these folks that this generation has given up more liberty than any other generation, and it was the fault of Barack Obama and the Democrats. That's nonsense. Part of the problem, and one of the major problems we had, is because that federal senator voted for the citizen detention provisions of the 2012 NADA. He was a major part in the government eroding our liberty. He's been voting for sustainable development, which is a principle inconsistent with liberty and inconsistent with American principles, for every year he's been up there, and he's been up there for over 10 years. And they sat on their butt, and they let him get away with that, and no one stood up and said, well, what are you doing? Why did you vote for these things? We're playing party politics. We're playing party politics, and we continue to elect the same people because they have an R or a D behind their name, and they're both playing us for fools.
Well, and I agree with you on several of those points. Am I talking to Richard?
Yes.
Okay. So now when you talk about the power to recall, do you mean states recalling the federal legislators, or are you talking about within the state?
I'm talking about within the state. Number one, a lot of this nonsense would be taken care of if the 17th Amendment was repealed.
Totally.
Okay? And I'm
right.
all for that, but I'm not for doing it. I'm not for doing it in a convention. And that's an acid test. If the citizens tell their federal delegation that they want them to propose and support and fight for a constitutional repeal of the 17th Amendment, and they refuse, the citizens ought to kick their butts out of office. But see, they won't do that because they don't want to kick a Republican out of office, and they won't do it. So that's the acid test of when we're making progress, is when you can get those federal delegation to do what the people tell them, rather than the special interests.
Who is it that doesn't want to repeal the 17th Amendment? I'm just trying to clarify your answer in my mind. Who is the they that doesn't want to hold their legislators accountable for repealing the 17th Amendment?
Well, this is Dave Donnelly, and I can tell you why I disagree with the effects on federalism that the 17th Amendment have, I still think the vast number of Americans want to vote for the U.S. senators, and it's kind of a fool's errand to say that's what we have to do, because that is never going to happen. You're never going to get you're never going to even get a strong minority to say they're going to give up their right to vote for their U.S. senators. What we have to do is seek other ways to restore the federalism consequences that the 17th Amendment had.
I don't understand that, and you hang out with different people than I do. If you understand the Constitution, you understand that the whole point of the states electing the senators was to give the states representation in the central federal government. That's what the point was. They no longer have, and since the 17th Amendment has been implemented, the states have done nothing but lost sovereignty. You can't have a federalist system like the founders wanted unless the states are in control of the Senate. That's the whole point. They've lost their representation in the government. It's ridiculous. Which just shows you that the states, if under the right circumstances, will cut off their own nose. Why would anybody do that?
I'd like to interject a thought here, if I can. This is Charles Kacprowicz. The first thing that I would like to address is that because the 17th Amendment got into this discussion somehow, I kind of agree with what Richard is saying. It's going to be very difficult to take the vote away from the people in the states. I would like to clarify state sovereignty through the state legislatures. Because of the vote, the people have the ultimate sovereignty, and they are represented by the legislatures being their representatives in the legislature. That's what Article 5 is protecting. Now, the fact is that the countermand provision, the countermand amendment, can actually nullify the 17th Amendment. It can actually force the Senate and the whole Congress to pull back and to put the hands of control back in the state legislatures. That's one of the beautiful aspects of the countermand amendment. The 17th Amendment can actually be doesn't have to be rescinded. It can be controlled through the countermand provision. And the next thought has to do with bipartisanship. There is no amendment that's been proposed, whether it be the term limits or the balanced budget amendment or some other amendment in the social area, there's none that is bipartisan. But the countermand amendment is bipartisan because every single state has an equal say in the outcome of any decision that is countermanded. And as a result, it'll be very hard for the legislatures to say, hey, we don't want that. As a matter of fact, I think it can turn around the elections in the districts in the states because if someone votes against the countermand amendment, they literally are going to say, we don't want our state to have states' rights under Article 5 or in this Constitution. And as a result, they would be hard-pressed to defend that. I don't care what side of the political spectrum they're on. So therefore, we have to rethink just what it is that we're up against and how to adequately and safely address them and successfully bring about values and laws that will protect our states' rights and state legislatures especially. So I just throw that in because I want to emphasize, nullification. Let me just quickly say something about nullification. There are a number of different definitions about nullification that have been floating around. But the one that I have always focused on is the idea that the states say to the federal government, no. They just simply conclude they won't do such and such. Now, what does that do? I'm for nullification. But what does nullification do? Well, go to Alabama and find out what happened with school busing. Or go Mississippi and go to the states that nullified by opposing federal mandates, and all of a sudden they found the federal troops all over them. Nullification is not an ultimate answer in everything. It may work in some situations, but I can guarantee that there will be circumstances in which the states will be up against federal military force when nullification is used.
One thing is you're not talking about constitutional nullification, and in fact, you're probably not talking about legal nullification at all. The states don't have the authority to ignore a federal law. They have a duty not to participate in an unconstitutional enactment. There's a heck of a difference between the two. And the states not following a federal law is anarchy. That's what it is. That's not the way it was set up.
But you see, that's exactly what happens.
The states don't have authority to nullify federal law. They never had it, and they don't have it.
I agree that the states don't have authority to nullify federal law. I agree with that. I am saying, though, that when it comes to a place where nullification is going to be used to oppose a federal mandate placed on the states that the states are opposed to, then it's one state against the federal government. That means it's a weak proposition for that one state. And it could very well, depending on the issue and depending on the law that's being opposed, that the states don't want to honor. At that point, there could be military action in the state. That's why that's the flaw that I see in the nullification concept.
But Madison and Hamilton both said that was the procedure. The states need to be working together. Now, if the states don't want to work together, I don't know what you do about that.
You pass the countermand amendment, and then only 30 states can countermand it, and all of a sudden it's nullified and rescinded.
That's a pipe dream. All you're doing is shifting the power, and you're doing it in such a way that you're going to maybe the other extreme from what we have now in the 17th Amendment. So but now you have a position where the states can lock up the government, and maybe they're going to lock up the government in pursuit of bacon. To pass Obamacare, certain states got certain privileges that other states didn't get. And you're going to see that same thing. It's like this big NSA spy facility in Utah that's like $50 billion. Maybe some of the other states would have liked to have a piece of that pie. Maybe they'd like to countermand that and let the federal government throw some money their way.
That is correct, but that'll put the federal government on notice that the states do have some rights, and they will be respected for their partnership in government.
And they'll be respected by the federal government bribing them, and we know the states will take it because the states have always taken federal bribes.
You're jumping the gun, Richard. You're making statements that are not on target with what I'm trying to talk about with the amendment that we're proposing, nor with nullification. The point is that when the states want to rescind a law or an EPA ruling or a court decision that is affecting them adversely, 30 states have to make that decision. And when they do, it's rescinded. There's no more issue about it. And then if the fact that the federal government doesn't want to enforce the mandate, that is the countermand, then there is an enforcement provision that says, look, if you are intentionally restricting this from becoming law or a practice in the country under this amendment, the countermand amendment, if you are deliberately and intentionally doing that, you can be prosecuted. That makes it a very powerful amendment.
Charles, this is Jeff. They can be prosecuted now. The founders and all 85 essays in the Federalist Papers in the Virginia and Kentucky resolutions, and including Madison's report on nullification in 1800, and I'm not counting it in the title, the founders used the term interpose or interposition 25 times to 1 time they used the word nullify, and nullify was a past tense use. The duty of the states is to interpose. They already have the authority, they just need to exercise it. Amending the Constitution or giving a countermand, they already have the countermand. It's called the Constitution.
They do not have the countermand. What they have right now is the right to oppose the federal government at great risk. That's what they have.
Liberty and freedom is all about risk.
I know, but you're twisting things. The fact is that they cannot enforce an action against a federal official because there is no provision in the Constitution that allows the states to do that. The states have no say in prosecuting a federal official or a federal non-government official who is intentionally opposing the enforcement of that provision or the protections of that article. So the point that you're making is really not applicable here. Enforcement in the countermand amendment makes it possible for the states to not only nullify and rescind a particular law, but it also allows it to protect that article so that the federal government, with intentional violators opposing that provision in any provision in that article, they can be prosecuted by state legislatures or by state.
So the enumerated powers become at the whims of the state legislatures. Then.
Not the whims. They become enforceable if the federal government doesn't do it within 90 days from the time of the violation. So the federal government's still in control. But look at the illegal immigration problem that we have. Why do we have it? Because they haven't been enforcing the immigration laws for the last 30 years. Now, the states, under that circumstance, with this amendment, they could step in and say, hey, wait a minute. You guys didn't enforce this down here on the borders, and you intentionally did it, and we're going to bring you to task for it. One state would have to lead the way. It may have to turn out to be a class action with the others, but now the people that are deliberately avoiding the enforcement of that guarantee in the Constitution and those laws under the immigration authority that Congress has, they are now at great risk.
This is Jeff. The states already have the sovereign authority and the constitutional duty to secure those borders themselves in the absence of the federal government keeping its duty of allegiance and protection. The states never surrendered their obligations of allegiance and protection. They never gave up most of their sovereign authority, if you will.
The fact is, there's a silent invasion that's been taking place in America for almost 40 years. Silent invasion. And what they've done is they have allowed these illegals to come in here. Now we have other problems dealing with drugs and terrorists and so forth. But they've allowed them to come in here without opposing it. The federal government wouldn't. Ask Arizona why the governor cannot get the federal government to help her down there to keep the borders secure. They don't have the authority to do it. That's the point. The Constitution doesn't give the states the authority to enforce immigration laws. But with this provision, they would have that. And they would say to the federal government, look, you've got to protect us. We've got X number of people coming over the border every day. We want that stopped. And they don't do it. Well, then they say, well, we're going to prosecute you, and we're going to enforce it ourselves, because they have an entirely different arrangement now with their Constitution in this countermand amendment. It's a whole different ballgame with this kind of balance. But at the same time, you notice that we said that it takes 60% of the states to countermand. Why did we do that? Well, we did it for this reason. Before the Constitution was created, and they were working under the Articles of Confederation, that unanimous vote requirement almost cost us the Revolutionary War, because Congress was unable to do anything without every one of the states agreeing. And as a result, they couldn't raise taxes, the inflation was going nuts, they couldn't feed the army. We almost lost the Revolutionary War because of unanimous consent requirement. And they had to find a solution to that. And that solution was 3/4 that were needed to ratify an amendment. Now that's the way they created the federal government, maintaining its authority and at the same time have a new constitution. We put in there 60%, 30 states, because we knew the federal government had a legitimate role.
How will that, this is Jeff, how will that make any of them uphold it at the federal, state, or local government? How will changing those words on the paper make anybody uphold the Constitution?
Through the enforcement clause. You know, it's one thing to have the federal government enforce it, and if the federal government doesn't, well, how do you think the governor of Arizona would have been able to use this kind of an amendment? She would have been able to enforce it against Obama.
Charles, this is Mike. Can I take that answer? And it's after 2 o'clock in the morning, your time as well.
Yeah, it's late over here.
Yeah, I know. Here's the real simple answer to that. If the countermand amendment were part of the Constitution, it's a passed amendment, then it's a ratification. And Eric Holder continued telling the head of DHS to disregard immigration law. Any of the sheriffs or the Attorney General of the state of Arizona or the Attorney General of Texas or the Attorney General of any of those states that are being directly impacted by these illegal aliens by that unlawful order, that unconstitutional order, which is a clear intention, then Arizona could easily extradite the head of DHS to Phoenix and take them and put them before trial. And that would be from the Attorney General's office. That would be from the Attorney General's office if they did it in Texas or New Mexico or Louisiana or Florida or any of those states. They could do the same thing. They could do the same thing with Eric Holder. They could put an extradition order out on him and take him to that state and take him before trial, and he's looking at 5 years mandatory minimum, no ifs, ands, buts about it. And that's for each count. So that's where this countermand really comes down to, is that if it gets down to that enforcement aspect, this isn't just a Joe Blow sheriff that's going to do something. This is going to be a state attorney generals through the governor, through the legislature, that is going to go after these people, and they're not going to like it one iota. And the first time it happens, it will be the last time it will happen, because they're not going to want to do it again.
So how much time should Governor Brewer get for participating in the lawsuit that Eric Holder filed against her in Arizona over SB 1070 when she participated in, she had Article 3, Section 2, Clause 2, the state's sovereign right and duty to go straight to the Supreme Court under original jurisdiction mandate, not an option, and she chose to take it to the lowest federal district court. How much time should she get?
And that's her decision, and that is her state.
It is not her decision. That was not her decision. It was the Constitution's decision.
If every one of us, under the Constitution, have a choice to do one thing or the other, we either reap the rewards of that, or we take the consequences of that. Now, Janet Brewer, she can be, next election, she can be outed because she didn't do her job. If the people of the state of Arizona said, you know what, you could have gone to the Supreme Court, you could have done this and this and this, but we're talking apples and oranges here.
No. We're talking about upholding the Constitution, and they could have done it then and didn't. Neither did the 26 states that were in the Obamacare lawsuit. They also went to the lowest federal district court. Article 3, Section 2, Clause 2 requires to go to the Supreme Court.
Alaska was one of the states that filed suit against Obamacare, so don't even go there with that. Because where did
they file it? Did they file it in the U.S. Supreme Court?
No, we were not silent in the Supreme Court.
No, did they file it in the Supreme Court, or did they file it in federal district court?
We filed it all the way up through the Supreme Court.
Not all the way up through. It was supposed to start there, not end there. It's supposed to start there. That's what the Constitution requires.
Well, whatever. Anyway, it's guys.
What do you mean whatever? The Constitution's now a whatever.
I'm not going to get into paper. Whatever.
Yeah, I'm not going to get into semantics with you, okay?
But it's a side issue. What you're doing is you're creating an alternate argument on something that's not related to the issue of countermand amendments and the power that Arizona's governor would have in enforcing the laws of this.
It's about the power she already has. And
she doesn't have it now. Even if she had it, she hasn't used it, of course, but she didn't use it because she doesn't have the authority of a countermand. The countermand would
She doesn't need the authority of the countermand
to
uphold the Constitution.
The countermand amendment would be constitutional. It would have the mandate that would require the Congress and everyone else to honor it. Now, the point that I'm making with that is simply this, that the laws that would come out from under this kind of an amendment would be subjugated to the countermand provision. So now that's the right way of turning things around. The point is, this is an amendment to the Constitution that says, look, Supreme Court, this is what you've got to follow. Look at Congress, this is what you've got to follow. Listen, Mr. President, you can't hold us back because you want immigrants to come over to get more votes. You won't be able to do that with this amendment because we can stop you. That's how powerful an amendment to the Constitution is, and it has to be single issue so it can be safe and successful.
Charles, I appreciate all of your passion, and this is just wonderful. This is Barbara in Seward, Alaska. I'm going to hand this over to Maria and let her make the final call on this call. So thank you very much.
You're welcome. Thank you.
Thank you very much, guys. I have about 1 million questions, but we'll have to do this again sometime. I'll let everybody who would like to exit the call exit. That's up to you at any time during one of our calls. But we'll close the official call, and then if anybody would like to stay on and argue and talk and just kind of go back and forth, you're welcome to.
I am going to end it myself, but thank you very much for inviting me. Thank you, fellas, for your participation. I appreciated both COS and the Defend Not Amend group and Patriot Coalition. I appreciate your favor as well. And hopefully we can find some common ground to get this nation back on the right path. Thank you very much. The Lord bless you all. Bye-bye.